Right. Okay. Thank you. And actually, I just wanted to pick up on a couple of points because, Kate, that was great, and actually very much reflects the experience of a lot of clients that we're working with, because this is pretty much what a lot of us lawyers at Field Fisher are now doing. We're all doing GDPR readiness projects for a lot of our clients, and we've got them coming out of our ears basically. And your experience very much reflected, what our clients are experiencing. But even though we've got these projects coming out of our ears, it's actually not that many companies that are doing these projects yet. A lot of companies are really, really far behind in terms of getting their arses in gear and doing something about getting GDPR compliant. But what some of them are doing this, and as they see it, as early. Well, we privacy lawyers think it's late, but they think it's early to the table, and a driver for it is competitiveness, because of being able to get a competitive advantage to implementing your GDPR program, being able to say to people that you've done it and basically win the trust of customers, be that individual data subjects or be it your corporate customers as well. So I just wanted to, thought that was a very interesting point and pick up on that one. Actually, and also another point as well I wanted to pick up on, big challenges that we're seeing a lot of our clients do. I think the employee data, absolutely, forgetting about that. It's not just about customer databases, but also the fact that for many, many years, a lot of these organisations have been gathering masses and masses of information across lots of legacy systems that may be secure or maybe not, and they don't even know what they've got, where they've got it. And one of the big problems they're finding, or our customers or clients are finding, is that suddenly we're saying to them, hold on a minute, you shouldn't actually be holding that information in the first place. So you've got to go through all of that information and get rid of what you don't need, and that in itself is a project and a half, just to get rid of that data. Right, so I'm going to give you a bit of a general experience about getting GDPR ready and planning for it. It's a bit less doomy gloomy than this morning's session about what can go wrong, and this is the remedy. This is how to mitigate the risks. Get yourself GDPR compliant and comply with the law. That's how you mitigate the risk. So here's everything you need to know about the GDPR. Not really. So yeah, we've summarised it into this very neat little slide, which makes it look slightly less frightening. There is more to it. So what does a good GDPR readiness strategy look like? You start with your business case. So this is, why are we doing it? You go to the board, you get your buy-in, you get your budget, and you get your stakeholders internally involved as well. And you kick off the project, because this is not a project that 1 or 2 or 3 person alone can do. This is a company-wide project that a lot of people from a lot of different functions and parts of the business need to be involved with. And if you're a multinational, sort of a group of companies, then actually you need to be doing this at a group level as well, and not each doing this in your own silo as individual group companies. You identify your project team. So who are the ones that are actually going to implement this project for us? And usually that will be a core project team, which might be, say, someone from legal, your data protection officer or other internal privacy person, if you've got one, your external people that may be helping with you with this, your project manager. And actually, depending on what sort of data it is that you're holding, you might have someone, say if HR data is, you have a lot of HR data, you might even have someone from HR on the core project team. You might have someone from IT or security on the core project team. And these are the people that will drive this project forward and then go out to the wider business and get people involved, including information gathering. So the information gathering, you collecting the information from all around the business about exactly what you're doing with personal data, why you're doing it, who you're sharing it with, where it's going, who has access to it, all of these things. And that, in effect, that's called a data mapping exercise. And we're also doing GDPR gap analysis for clients as well. So we are we're analysing where they are now in terms of their compliance levels and what are the steps that they need to take to get themselves up to GDPR compliance levels. In that data gathering exercise involves usually sending out questionnaires, which, as Kate mentioned earlier, and getting people to fill them in. Particularly if you're a large organisation, that can mean a lot of questionnaires and a lot of information. So we're increasingly being asked about automated tools for doing these things, and we ourselves are doing this in a more automated way nowadays. In fact, there's one particular provider, OneTrust, that we are working with, and that's a way of sending out these questionnaires electronically, sending out your data mapping questionnaires, gathering all this information in, and it creates some very, nice data maps. Does other things as well, so you can you map all the risks that you're identifying. You can keep your data protection impact assessments there, so all sorts of useful stuff, because we're talking about a hell of a lot of information that you're going to need to gather for this, but also a hell of a lot of information you're going to need to keep going forwards on an ongoing basis. So we do the gap analysis, and then you get your GDPR readiness report. So this is, everyone is unready. Nobody is ready for GDPR at the moment. This law is not, currently in force. You're not having to comply with it at the moment. There's new things coming in. So everyone will have something to do to a greater or lesser extent. You then, having got together your report, which in our case we also set out all of the exact actions that we think you need to take, we then would help you put together a project plan, because this is a project, and the plan will set out exactly what we think you ought to be doing and when you ought to be doing it, and then we will talk to you about that and rearrange the plan based on what you tell us, because actually there might be all sorts of things going on within the organisation. Some things might have more priority for the business, others might not. So there's a lot of factors. You end up with a plan that fits the business. And then you move to implementation. So this is where you're rolling out your plan. So that's what a good strategy looks like, and sounds like exactly what Kate's been doing. It can also look like this. I've cut a few sections out here, not doing the information gathering piece and the gap analysis piece. You can do it that way. It's not as good. I'll tell you a few reasons why in a minute, but a lot of organisations, particularly smaller ones, don't want to go to the actual considerable effort and at sometimes considerable expense, especially if you have to use lots of consultants to help you with this, of doing all of that information gathering stage and gap analysis. And they are saying to us, and we're rightly saying to them as well, actually, do you know what, skip that. Just go to the implementation, because we have a pretty good idea of the sorts of things that you're going to need to do to get yourself GDPR compliant. Why don't we just do that? And a lot of organisations will have a very limited budget, so you might not want to spend it on that analysis stage. You might want to just go straight to sort of creating the right policies and updating policies and rolling out training and things like that. So you can do that as well, so that is an option. You'd still need a project plan, because you don't want to just go at this willy-nilly without any plan. And you implement. What you don't want it to look like is this. And I think this is actually where the vast majority of organisations currently are. They are trying to eat an elephant. It is just a ginormous mountain that they're standing at the bottom of, and they have absolutely no idea how they're going to get to the top. Just a little bit about the value of the assessment and reporting stage. You might not want to do it, but if you can do it and you have the budget to do it, I would say do it. And the reason being is that it is surely a good thing to actually understand what personal data you are processing within the business, why you're doing it, whether fundamentally you should be doing it and are allowed to do it under data protection laws. So that means gathering information about your personal data processing. It will also underpin all of the things that you do around, say, data protection impact assessments, drafting of your policies and your processes and your privacy notices, to make sure that they're absolutely right and accurate and relevant to your business. The training that you give, data retention and destruction, your security assessments, data transfers outside of Europe. How will you put in place the right agreements if you don't know what data is where and where it's going? It will also help you understand how the GDPR requirements are actually going to impact you in practice, because you are looking at what you're doing in practice with data and then thinking about how the GDPR actually impacts on what you're doing with data. You can plan better and you'll make better decisions, I think, if you've done the gap analysis. You'll be able to start thinking about whether you should actually be processing this data in the first place and getting rid of data that you don't need to be processing or shouldn't be processing at all. It's also going to help you with your Article 30 obligations under GDPR. So we heard earlier that we're getting rid of this, the requirement to register with the Information Commissioner, which actually is a piece of cake anyway. They're replacing that with extremely extensive record-keeping obligations, which are not going to be a piece of cake. Basically, going forward, you're going to have to document absolutely everything that you are doing with personal data. And that's Article 30. And to do that, really, you have to have a pretty good grasp of what you're doing with it. And so I'd say do the assessment if you can. So, what does a typical implementation plan look like? So I think of it as 3 stages to your, this is the actual rolling out, the implementing of your plan. There's the looking at the strategic issues and decision making around that, first off. Thinking about, for example, which group entities are actually caught by this. You might think that's an obvious question. The answer might not be so obvious, particularly if you're a multinational. So you might have offices around Europe. You might have headquarters in the US. You might have offices in other non-European countries. Okay, everyone in Europe's caught, we know that. But actually, the GDPR goes beyond Europe. It will also apply to non-European entities if they're doing certain things with personal data of entities of people within Europe. So you have to think about whether your group companies outside of Europe are caught by this legislation as well, and have those conversations with them. Often there's a great deal of surprise when you have to go to your US headquarters and tell them they're going to have to comply with European law, and resistance, may I say. Figuring out who your lead supervisory authority is. If you're just based in the UK, it'll be the ICO. If you're not just based in the UK and you've got offices around the place, around Europe, you're going to need to think about who your lead supervisory authority is. We were having a conversation earlier about how the ICO is a bit more lenient. Well, actually, the bad news is, if it turns out that most of your compliance is driven from Germany, for example, the lead supervisory authority for you in Europe may well end up being Germany. And they might not be as lenient about how they enforce all of these things. DPO requirements, so thinking about whether you need a data protection officer. For some organisations it will be mandatory, for others not. For some, you might want to have a DPO anyway. And then thinking about how this works from a governance perspective. If you have a data protection officer, that data protection officer can't just be anybody. You have to think about how they report in to your management, because they have to report to the highest levels of management. So you can't appoint the office junior as your DPO just because they have the least say in the matter and couldn't say no. It's probably going to have to be someone, reasonably senior, because they've got to report into your senior management. You've also got to think about who best fits that role. The latest guidance that's come out on DPOs from the Article 29 Working Party, who's this European Commission Data Protection Working Party, and who will eventually be our Data Protection Board in Europe. So they will, from a statutory perspective, have quite a lot of power. They are saying that it cannot be anybody who has any say over how personal data is processed in your business. So quite often the DPO is your IT person. It can't be them. They can't be your DPO, because actually, if your head of IT is has a steer over how you process personal data, they can't also fill that function of DPO, because there will be a conflict in their roles. And the bigger you are, the more skilled your DPO will need to be. That's written into the legislation, by the way. So if you need a DPO, start looking for one now, because I'm telling you, there are not enough to go around. You'll also need to think about your technical and organisational changes. So a lot of these requirements that we're talking about, it's not just about putting policies in place and updating your privacy notices. A lot of them will require some absolutely fundamental things changing within your business in terms of how you collect, how you store, how you keep data. So actually, it's changes to your IT systems. It's changes to exactly what data you keep. It's changes to how you extract data from your system so you can provide it to people. And that, actually, when we did the consultation in the UK on this piece of legislation some years ago, a lot of organisations that fed into the consultation, things like right of portability and subject access rights and sharing of what information you need to share with others, all of these things were a very, very big concern, because people recognised it means changing to your IT systems, and that can be really expensive, actually more expensive than a lot of other things that you need to comply with from a GDPR perspective. So that's the first layer. It's the strategic issues and decision making, and I think that's what you should start with. Then you start gathering together all of the documents that you have within the business that relate to privacy, and you start looking at those and thinking about what all of the additional things that you need which you don't currently have. So because you might have stuff already, but it'll need updating. There might be things that you don't have at all, completely new things like policies around how people exercise all of these new subject rights that they're going to have, like right of portability, right of, I call it like a right of ring fencing, a right to have their data ring fenced within your systems, all of these sorts of things. So, and then training materials, because this is going to be absolutely key. These are training materials for your people within the organisation, because it's all very well having all of these policies, but if nobody understands them, nobody gets trained on the basics, and nobody has in their minds that actually as an organisation, our culture is that we do the right thing with this data and make sure that we're compliant, then you might as well have not bothered. In fact, currently that's also the case now, and a lot of incidents and investigations that we deal with, the very first thing the ICO will ask is they want to see all your policies and procedures, but they might follow up with, and tell us how you roll this out and how this gets implemented. You know, they are wise to this fact that you might well have it on your intranet, but no one's ever looked at it. Implementation. So this is the next phase. So once you've identified what needs doing, you then move into the implementation phase. And this is actually all of the updating, and this is all of the rolling out and doing all of the training. So that's the project to get yourself GDPR compliant. Then after that, you have to stay compliant. So you'll obviously need to keep on top of all of these things. I thought you might be interested to see a real example of a very, very high level project plan. Obviously anonymised. So that you can see, once we've started to think for a client, what are the areas that they're going to need to focus on. Let's make this a bit real, as in, what's this project going to look like? And I must emphasise, this is high level. Sitting underneath this, as you go through the project, we also work with Excel spreadsheets where we detail the actions, who is doing what, by when, and progress, etc. So there's a lot more detail behind it. So Customer contracts. So if you're this particular customer is a processor for a lot of its customers. So they need to look at their customer contracts to understand what they are committing to currently in terms of data processor clauses, and what they need to commit to going forwards in terms of data processor clauses. A word of warning for if you are a data processor. Until now, it's pretty much been the controller's obligation to make sure that the processor clauses that we need now, which are not that significant, go into a contract. That is a requirement currently under our laws. Going forwards under the GDPR, on that particular clause, it's Article 28, by the way, of the GDPR, if anyone wants to look at it. They've not been specific about whose obligation it is to make sure that these processor clauses go into the contract. So although probably I'd say it's more something that's going to fall on the controller, there is a chance that you as a processor could technically be responsible for making sure that your customer imposes an awful lot of very onerous conditions on you in contract. And if you don't do it, then by the way, you can get fined, as per my earlier talk. It's a finable offence. So the other thing that you also probably then need to start thinking about, particularly if you're a processor, is not just putting these Article 28 clauses into your contracts, but hold on a minute, as a processor, we could be exposed to massive liabilities here, which currently we don't have, or we manage to ring fence a little bit via our contract by imposing a liability cap and excluding certain types of liability. Going forward, technically speaking, as a processor, we could well have the regulators coming after us directly for breaches of GDPR, which we were supposed to comply with. Now, we wouldn't be in this position technically, but for the fact that we're providing a service to the customer. How do we pass some of this risk on to the customer? And you do that through the contract. So a lot of clients that we're working with, particularly processors and very big IT providers, cloud providers, for example, they're thinking about exactly this, how to pass on risk to the customer or ring fence their risk around GDPR. You will also, as a top priority, want to start thinking about your very strategic PIAs, or DPIAs, as they will be called under the GDPR. And you're probably thinking, what's a PIA? That is a privacy impact assessment. Going forward, it will be called a data protection impact assessment. It's the same thing. What is a data protection impact assessment? It is somewhere where you document what your obligations are, and in a sense of a project that you're about to undertake that involves personal data processing, or a system that you're looking at, you document how you're going to comply with the legislation and think about it, and then actually make sure that you comply with it. So that is a privacy impact assessment. In some cases, it's actually going to be mandatory under the GDPR that you have to do these privacy impact assessments. So it's particularly for higher risk processing. So, big, high volume databases, more sensitive information. If you're embarking on a new IT project, which you may well be from a GDPR perspective, you will be doing these data protection impact assessments. So think about your strategic ones. Data flow mapping around the group. As Kate said, you don't just think about your processors and external third parties. Think about how data is flowing around the group, and because that will then lead on to agreements, for example, that you need to put in place within the group as well as with third parties. Determine your lead supervisory authority. Look at your processor contracts with your processors and your data transfer agreements with them. And actually, although the requirements in the GDPR are the same in terms of what needs to go into the contract, from a contracting and risk perspective, how you phrase things or frame things or additional stuff that you put into the contract with your processors might be slightly different to what you're willing to accept when you're the processor. Make sure you've got your incident response plan sorted out, which I'm sure you've all got one. Make sure it's GDPR ready, so you can do everything that you need to do within 72 hours. Make sure your web privacy notice and cookies policies are up to date. Now, this is the sort of thing that we, when we're doing these projects for clients, would categorise as top priority, do immediately. The reason for the bottom one is because your website is your window to the world, and everybody, individuals, regulators, everybody, has a very easy way of going and having a look and getting a bit of a flavour for how good you are in terms of compliance. So if you have a wholly inappropriate and out-of-date privacy notice on your website, and also you've got a wholly inappropriate and out-of-date cookies policy on your website that says, by the way, we use cookies, you can reset your browser, for example, which actually even currently you're not supposed to have under current laws. Slightly separate piece of legislation on cookies, but it's the same regulators that look at it. People are going to know that you're not taking data protection seriously. So, sort your shop window out. So in terms of medium term, what do you do next? Employee privacy notices. People forget that employees are data subjects, and actually quite often you can be handling a lot of information about them that is way more sensitive than the information you handle about your customers. So that means that they're entitled to every single right that anybody has under the GDPR, including that you are transparent with them about what personal data you're processing, which means you need to give employees a privacy notice. And your 1 or 2 paragraphs in your employee handbook that you probably currently have won't cut the mustard, because really what we do with employee data nowadays is quite complex. And on top of that, the GDPR specifies exactly what you need to be telling people in privacy notices, and it is a list that is, well, I just did a checklist for a client and it was a page long, just a checklist of the stuff that needs to go into the privacy notice. That's not the privacy notice itself. So you need to sort those out. Sort out your employee data protection policy and your data subject rights. So your employee data protection policies is really I would say that's your training manual for your employees about how they need to go about dealing with personal data. So this is about making sure your employees have a internal roadmap about compliance and what they need to do to make sure you as an organisation remain compliant. You'll also need a data subject rights policy. So at the moment, you may or may not have a subject access requests policy. That subject access request policy may now need some accompanying friends around all of the other rights that are being introduced, so that you have policies to deal with all of those other issues. Particularly if actually you think those rights are going to be exercised a lot in your organisation. Some of them you might decide, actually, I don't need a policy because it's that right probably is not going to be exercised against us, and if it is, then we'll send it to Kate or compliance, and they can deal with it on the odd occasion that we get that. So, employee GDPR training, make sure that you roll out your training. Look at all of your consents. Should you have been getting consent in the first place, or should you have been relying on some other legitimate processing grounds which are set out in the legislation itself? Look at all your intra-group data transfer arrangements, because it's very rare that in multinationals that they operate completely in silos and never share any information or systems or services. Data protection by design and default, so this is build in everything that you do, GDPR into everything that you do. Record keeping I already talked about, and because I'm running short on time, I'm going to skip the low importance ones and move on to this. Don't just dwell on the most obvious of your policies. Actually, data protection, security, and information governance comes into play in a lot of policies. So think about the non-obvious ones as well as your consumer terms and contractor terms, recruitment policies and notices, BYOD, any monitoring of employees that you do, and policies for that. IT security, retention and destruction. That's a really important one, because you're going to have to only retain data as long as necessary. that's a requirement now, but not many organisations comply. So you need to make sure you've got a good data retention and destruction policy and understand exactly how long you're going to keep personal data of different types of personal data. That's quite a lot of work, and then you've got to get rid of the information that you don't need. Another reason that you need to understand how long this data should be retained is because you're going to have to, that's one of the things that you're going to have to put in your privacy notices going forwards. You'll have to tell people how long you keep their data for. Complaints handling policies and social media policies. So that's just a few. I've got a really long list of them back at the office of other things, other policies, but I thought I'd pick out just a few. Useful resources. So we've heard about the Information Commissioner's Office and the resources there. Field Fisher, useful resources. So that's who I work for. You might be interested to know we've just launched a free app in conjunction with OneTrust where you have the full text of the GDPR, and we have very handily basically done a link to each of the relevant recitals against each provision of the GDPR for you, because at the moment the recitals don't specifically say what bit of the GDPR they relate to necessarily, although you sort of have to guess from the context. What we've also done within the app is we've drawn together the Article 29 Working Party guidance as it is at the moment. There's a few guidances around like DPOs and privacy impact assessments. They're all accessible via that, and we will keep that updated, so it's a really good place to go and find the guidance. Otherwise, it's very difficult to find. I was trying yesterday. I can't find it just through a Google search. So the app will be good for that. And we have a privacy blog, and as you can probably imagine, we are putting out lots of useful blogs around GDPR compliance issues, which you might find helpful. In fact, the one before this, 10 Steps to Operationalise Your GDPR, was my blog, which is about thinking about your data processor clauses in contracts. And the Article 29 Working Party themselves, so they really are the definitive authority to go up to at European level and look at their guidance. Their guidance on the legislation is not necessarily always clear, so you'll probably regularly see articles from us trying to interpret the guidance for people like us, who are finding it confusing. So that's your compliance plan in a nutshell.
Thank you ever so much, Kirsten. Again, thank you very much.